Good morning, everyone, and welcome to today's Go Fly Master Lecture. To get us kicked off, I'd like to introduce Gwen Leiter, CEO and founder of the Go Fly Prize, to introduce our speaker today. Gwen?
Thank you, Paul, and welcome everyone to today's Master Lecture. As you all know, the Go Fly Prize is sponsored by Boeing, who is our grand sponsor. In addition to Boeing, we are supported by a number of different partners, including our in-kind sponsors and our organizational partners. So today we have a very important master lecture for you all. We are so pleased to welcome Frank Occhiuti to deliver this master lecture. And Frank is an intellectual property attorney, and he is co-founding partner of Occhiuti and Rolacek. Frank is a highly accomplished intellectual property lawyer with a specialized focus on building robust patent portfolios for global high-tech companies. In the field of aerospace, Frank has helped companies and universities build portfolios related to aerospace technology, including aircraft fuselage manufacture and drone flight. And prior to founding Occhiuti and Rolacek, Frank was a principal at Fish & Richardson, a global intellectual property law firm, where he developed and managed the patent holdings for a diverse range of companies and technologies and counseled clients on complex patent and trade secret issues. Prior to joining Fish & Richardson PC, Frank worked at Raytheon Company in their patent department. And prior to his law career, Frank worked for more than a decade as an electrical engineer in the defense electronics industry, focusing primarily in designing and developing sophisticated high-frequency communications aboard large-scale defense systems. He holds a bachelor's degree and a master's degree in electrical engineering from Northeastern University. He has lectured internationally on patent portfolio building, and he is a long-standing member of IEEE and a member of the Northeastern University's Industrial Advisory Committee. So without further ado, we are so pleased today to welcome Frank Occhiuti.
Thank you, Gwen. So let's get started. There's an awful lot of material here that we want to cover. And I would like to just start with just what we're going to try to accomplish in this discussion. I'm going to talk a little bit about types of intellectual property, and this is going to be relevant because we're going to be talking about things like patents and trade secrets. And then we're going to get into the meat of the discussion, which is going to be about patents, what protection is and isn't afforded by patents, what can and cannot be patented, what are the patentability requirements for an invention, and then what's generally included in a patent application. I should just preface this by saying that a lot of this, I'm a US patent attorney, so a lot of this is going to be coming from a US perspective. And in the area of patent law, or law in general, the laws are governed by individual countries. And so there may be differences in how things are characterized in terms of the patent laws. And you will always want to check with your, the patent attorney in your own country or in your own jurisdiction to be sure that it's consistent with some of some of the ways that I'm characterizing it. So let's get into, first of all, just to get a sense for what are the different types of intellectual property. The first three on this list, utility application, provisional patent applications, utility models, and design patents are all patent related. These are all forms of intellectual property that relate to patents. Intellectual property also includes trademarks, copyrights, trade secrets. There are others, but these are sort of the main ones. Again, patents are associated with covering inventions. Trademarks identify the source of a company, a company or an entity's products or services. Copyrights cover creative expressions, books, recordings, software. Design patents. Well, let me step back. And then there are trade secrets. We're going to talk a little bit more about trade secrets and how they relate to patents. In terms of patent applications, the main one that we're going to be talking about are utility patent applications. And when I talk about patent applications through the rest of this program, I'm going to be generally referring to utility patent applications. In the United States, and it's pretty much just a characteristic of US patent law, there is a provisional patent application, which is a way of filing a patent application and giving the inventor or the applicant time to decide whether or not they want to continue and pursue a utility patent application. So generally, if you file a provisional patent application, if you're going to proceed with protecting the invention, you will then go on to file a utility patent application. Design patents are intended to cover ornamental appearances of a product. So, you know, the shape of a blender, or you know, the sole pattern on an athletic sneaker are examples of things that are design patents. In terms of patents, you apply for a patent. It is examined by the respective patent office in which the application is filed, and then if you're successful in getting the patent, it then will issue and you have a granted patent from your patent application. Provisional patent applications are never examined. That only happens when you convert your provisional patent application into a utility patent application. And again, that's only a US characteristic. In other certain countries, for example, in Germany and China, they have a utility model. It's a patent where you apply, it gets registered, it's never examined, and it only becomes subjected to some examination if it's challenged. For example, if someone's an infringer and you want to go after them, then it's then evaluated as to whether you were entitled to the patent in the first place. Trademarks, they arise with use. There's no requirement to actually file in the United States anyway, there's no requirement to actually file for trademark protection. You have it through common law, but to get federal protection, and there are advantages to that, you have to register and there is an examination. Copyright, you automatically get copyright when you affix it on a tangible medium. The circle C is representative of the copyright here in the US. And trade secret is simply that you don't tell anyone, and you try to protect it as a trade secret. How long did each of these forms of intellectual property last? These are in general for a utility patent, it's 20 years from the filing. There may be extensions that you are afforded if there were delays caused by the patent office. Provisional patent applications, they self-destruct after a year. Utility models, it depends on the country, but they usually last about 10 years from the filing. Design patents, again, are country dependent. In the United States, it's 15 years after it's been allowed. Trademarks last potentially forever as long as you're using it. And copyright, it's really a very complicated, evaluating the length of a copyright, it's hopelessly complicated, and it also depends on the country. And trade secrets last potentially forever, unless hopefully, you know, no one leaks the trade secret. And here's just a slide to just show you how a product can actually be covered by multiple forms of intellectual property. So here I've got this Mrs. Smith's apple pie. The name Mrs. Smith's associated with apple pies it could be a trademark. The logo itself is a trademark. The recipe for how you make it and the way that you actually cook the pie could be potentially a patent for the recipe. The fluted rim of the pie crust could be the subject of a design patent, and of course the design of the painting on the box is subject to copyright. So that just gives you a sense for the different forms of intellectual property. People often sometimes misuse those phrases. They'll say like you should trademark your invention or you should patent that slogan. And so I thought it'd be helpful to quickly go through that. So now we're going to get into the meat of into the patent discussion. And the patent is essentially a contract between the government the patent office and the government that is supporting the patent office and the inventor. And it's essentially the idea is that the government is going to give the inventor a time-limited monopoly to prevent others from making, using, or selling their invention. And in return for that, the inventor is going to share and reveal their invention to the public. And at least here in the United States, the forefathers, when they came up with the idea of having a patent system in the United States, the idea was that the country would improve if inventors were willing to share their ideas so that others could learn, and then maybe possibly improve on the invention that was submitted by the first inventor. And so in that way, the country would, the technology would improve, and the country could grow and become, we would have a more technologically sophisticated country. So that is the idea, and in essence, the government is essentially trying to discourage people from keeping trade secrets. So to segue into that, so the idea here is that the government wants you to disclose, and obviously they're not going to give you a time-limited monopoly to exclude others from practicing an invention if you've already disclosed it. So a key thing here is that you, before you actually file a patent application, it's important to try to not disclose your invention to the public, because having done so, you probably, in many cases, you may be forfeiting your right to pursue protection. And here in the United States, the public disclosure is any non-confidential communication which an inventor makes to the public, revealing the invention and enabling a person having skill in the art to reproduce the invention. In the United States, you have a grace period. There are a few countries that offer grace periods. I think Canada and Japan may be other countries that offer a time-limited grace period where you can disclose your invention, but then you start the clock on you have a certain period of time before you have to file a patent application. I'm going to go very quickly through the definitions of this, but so non-confidential is essentially, that you're not requiring any secrecy by a person receiving the communication. So a non-disclosure agreement, if you were able to get a non-disclosure agreement, or if you shared your invention with someone who was willing to agree to keep your disclosure and the invention secret, then that would not be considered a public disclosure, at least here in the United States. And again, this is something that you need to you check with the local law as to what is a disclosure. Different countries have different rules, and what is a disclosure in one country may not be a disclosure in the next country. So it's always good advice to if you're considering patenting or trying to pursue a patent on an invention of yours, it's always best to consult with a local attorney in your jurisdiction to be sure that you're not disclosing an invention, or to figure, to understand what things you need to do in order to keep it from being a non-confidential disclosure. So what are patents? And one important point here is that a patent is not self-enforcing. And what I mean by that is that if you're successful in getting a patent, just because you get a patent doesn't mean that someone won't go and practice your invention. So in order to enforce your patent, you may have to resort to a court action to get the court to force the infringer to stop patenting. And you have to do that in each country. So it's important to understand that the patent that you get in the United States is not going to be generally not going to be effective in preventing someone from practicing that invention in Canada or in Japan or in other parts of the world, you need to get a patent in each one of those countries. And I will be talking a little bit about international protection. An important point is that a patent is not a right to practice any invention. There may be other patents out there that, in fact, will bear on your ability to even practice your own invention. And I will have a slide later on in this discussion that gives an example of how that works. So yeah, trade secret is as I said before, is essentially, it's sort of the antithesis of a patent. The inventor has to keep the detail secret. Examples of a trade secret, the famous ones are like the formula for Coca-Cola, the recipe for KFC's chicken. It's important, though, that the trade secret be kept secret, well protected. Companies like Coca-Cola and KFC, spend a lot of money and a lot of time making sure that their trade secret doesn't get disclosed, because once it is disclosed, then even if by accident, then it's now in the public domain, and the trade secret disappears. But unless that happens, it can potentially last forever. What can be patented? Patents can cover processes, methods of doing something. That could be a method of using something, method of fabrication, how you make something. If it was a semiconductor chip, how you actually form the semiconductor chip. Patents also cover apparatuses, machines, manufacturers, components, the components that make up a subsystem, and then the system that has the components of the subsystems are all potentially patentable subject matter. In the chemical and pharmaceutical areas, composition of matter is also something that can be patented. Things that can't be patented, or I shouldn't say cannot be patented, but generally are difficult to patent, are things that are related to abstract ideas. Laws of nature are generally not patentable. You can't patent Pythagorean's theorem. You may be able to patent use of the Pythagorean theorem in some methodology for or making of some device, but generally abstract ideas and laws of nature are not patentable. And again, this is a country-dependent thing. It's becoming more and more difficult to patent, particularly in the United States. It's becoming more difficult to patent things that are related to abstract ideas, and for example, software related to financial systems, accounting. Those things are becoming more and more difficult to patent. And in general, the inventions without any real-world use are generally not patentable, although that threshold is a pretty low one. There are a lot of things out there, a lot of patents out there that cover things that people probably would consider to be not very useful or difficult to implement. And so, as an example, I thought it would be helpful to go through a patent that I actually found, and this is a US patent that's directed to a personal propulsion device. This one was filed, I think, back in around 2004 or so, I think. It took 7 years for it to get through the system, and it ultimately issued in 2011. And if you look to the figures, essentially what it is it's a propulsion device that is worn by the user, and there is a body unit that is placed in the water that has a motor and a pump, and there's a sort of an umbilical cord that connects the unit that's in the water with the body unit that's on the back of the user, and the motor pumps pressurized fluid into the jetpack or the propulsion unit so that it can propel the person. So what are the kinds of things that could have been patented from this invention? And in this case, there were about over 100 claims that were directed to the method of using this system. But I went a little further to look at things that could have been potentially patentable based on what was described in the patent application. So in terms of things that were device or system related, there was the propulsion system itself. For example, the geometry of the thrust nozzles might have been unique. The pump turbine design, the umbilical conduit and how it connected, the interface between it and the body unit, those are all potentially patentable inventions. The body harness mechanism, how it is able to be worn by the user, and for example, how may have a quick release mechanism. Other inventions related to the methodologies include the method of assembling the propulsion system. There could be a stability control algorithm. There could be a control loop for controlling how the thrusters and the pump units interact, and the method of using the propulsion system. And then, going to that design patent thing, the ornamental appearance, the overall design appearance of the propulsion system could also be subject to a design patent. Excuse me. So one of the things that I thought was interesting in this patent was, despite the fact that the claims, and I'll talk a little bit more about what the claims are, the invention that was covered really related to this idea of having this body unit in the water, and it was used for flight. But some of the things that they talked about in their patent application that could potentially also have been patentable was the examples of how this propulsion system was used. And they talk about, for example, using it for ship-to-ship personnel transport. So if you wanted to be able to move from one ship to the other, you could use this propulsion system. They also talked about a land-based application in which it was used, I think, in an amusement park or in a heavily a traffic area where you wanted to have someone who could look over, let's say, a clover leaf of a highway system. And here they show, for example, how there would be some source of water for the propulsion system, but there would be it would be limited in the distance that you have to go. And then finally, there was also being able to do low detection underwater travel. So let's see. Now we get to the standards for patentability. What does it take for something to be patentable? This again is going to be dependent on the country, and there are standards for what makes something patentable. In general, there are two main requirements. It has to be new, and that's consistent across all countries. Something that's old and in use isn't going to be patentable. So novelty is the first prong, and then the second one is whether it's inventive. And in the United States, we call that it has to be non-obvious. Places like Europe, they say it has to have inventive step. It's the standards for what makes something inventive and non-obvious is another thing that's, as I said, is country dependent. But an example of something that isn't would be obvious is if you just changed the scale or the size of something, or you substituted, for example, copper for silver if it's for electrical wire. It would be difficult to say that that's patentable. In the United States, we do require things to have utility, and that goes back to the abstract idea. So in terms of what a patent application has to include, again, this goes back to this contract that you have with the government, and that is that you have to be able to provide enough of a description that somebody is able to actually use your invention, know how to make and use your invention. So it's not enough to be able to you can't get a patent without really disclosing, how you actually make and use it. And generally, there are the figures and the description, and then there are examples for how it's used. The drawings are very important and effective, particularly for mechanical inventions, to show what the components are and the elements of the invention are. So the patent application has this written description part. We call that the specification. The drawings are associated with the specification, and the specification refers to the drawings. And then at the end of the patent application, there are the claims. So these are the numbered paragraphs that describe and create the boundary of what the invention is. It's like the property deed of your house, where it defines the outer boundaries of your property without necessarily describing the details of the specifics of what's inside that boundary. The claim, as I said, is a one-sentence description of the invention. Generally, the fewer the limitations that are in the claims, the broader the monopoly. The claim can't cover the prior art, and so when the patent application is submitted and it is examined, there is a person at the patent office, in each respective patent office, an examiner who is going to look at the claim and then go and do a search for prior art to make sure that the characterization of your invention doesn't, in fact, cover, or isn't, that the claim wouldn't cover something that's already in the public. If it is, then you will get a rejection, and the examiner will generally, suggest that you narrow the claim so that it doesn't cover the prior art. The claim puts the public on notice of what is and what's not part of your monopoly. And I have an example here in referring back to our personal propulsion vehicle. You can sort of think of these claims as a Venn diagram, and the broad claim is obviously the largest circle here. And just as an example, I actually wrote this claim, simplified it to some extent, but imagine that the propulsion vehicle has, at the basic level, a body unit with a thrust assembly. There's a base unit that's in fluid communication with water, and then there's a conduit that connects the body unit with the base unit. And that would generally cover that figure that I showed you in the earlier slide. As a dependent feature, an important feature, we have these numbered dependent claims that refer to the broad independent claim that narrow the claim, but also are important for defining the invention. So the personal propulsion vehicle could also have a navigation system, and that would, so essentially, if you look at the Venn diagram, the smaller circle 2 is part of the larger circle 1 that's defined by the independent claim 1. Also, you could then have another dependent claim that recites that the body unit has a torso corset. So these are other features that might not be necessarily infringed by a competitor. If they didn't have a torso corset, they might not infringe dependent claim 3, but they would certainly still be within the broader scope of claim 1. And then I also added another independent claim where we have another characterization of the invention to the personal propulsion vehicle, where you have, again, the body unit, a base unit, a conduit connecting the body unit with the base unit, and a harness assembly. Now, here, what's different is that this claim is narrower in some respects, but could be broader in other respects than the claim. So let's move on to the claim scope. So, and I wanted to highlight this aspect of a patent claim, because I think, well, earlier in the slide presentation, I talked about the fact that a patent a right to exclude, but sometimes doesn't give you a right to practice. But I want to give you an example of that. But here, if from the standpoint of claim scope, if we had a claim that was directed broadly to a vehicle comprising a motor and two wheels, well, you could see that that a vehicle comprising, and comprising is an open-ended term. It means that it has these things and it can include other things. It's not limited to these two things, but anything that has a motor and two wheels would be covered by this claim. And that would, so you can see that this claim would cover a motorcycle, an automobile, and a truck, because all three of these things have a motor and they have two wheels. What it would not cover is a bicycle, because although it has two wheels, it doesn't have a motor, and it might and it would not cover a powered vehicle that only has one wheel. So so this shows how a claim, you know, how a claim can cover many different characterizations of you know, of a vehicle. And getting back to my point about it, about the right to exclude, if somebody actually had a patent, someone earlier had a vehicle that was to a vehicle comprising a motor and a wheel, the person with the patent to the motor with two wheels might not be able to practice their invention to a motorcycle, car, or truck, because they could be covered by the patent with the motor and a wheel, because all three of these embodiments of a motorcycle, car, and truck, in fact, have at least one wheel. Okay. So as part of this examination, you know, the patent is examined in view of what is already in the public domain. So we call that the prior art. And what is the prior art? Well, it's anything that's in the public before your filing date, and that could include other patents, journal articles, textbooks, conference presentations, any disclosure that wasn't under some confidentiality agreement, like an NDA. Some exclusions for the inventor's own work are not prior art. That would be excluded, but that's usually for a limited time, and that's what I was referring to earlier, where, for example, in the United States, you have a grace period. Again, different countries have different rules, and so you would want to check with your attorney in your own jurisdiction to make sure, you know, to understand whether something is prior art or not. So in terms of protecting an invention that you have, again, what does your application give you? Again, it excludes others from making, using, and selling. In general, it excludes, and again, that is in your country. And that's why you would need to get, if you want to have protection in other jurisdictions or worldwide, you need to get protection in all of the individual countries. Generally, and that's once the patent application is granted or issued in the country. It generally will exclude import into the country that you have a patent if it's made elsewhere. So if you have a U.S. patent and you don't have a Chinese a patent covering the invention in China, somebody in China could make and use the invention in China, but they would not be able to import that product into the United States, because they would then be violating your patent for selling it in the United States. The other reason for filing patent applications is that once they're published or they're issued, you're essentially creating prior art and making it more difficult for other competitors or others to pursue patents in that same field or related to the same invention. Again, as I said earlier, the patents are jurisdictional. There is no such thing as one international patent. If in order to get protection in each country or in a region, you have to get a patent in each of the countries. There are regional patents. For example, you can have a patent application examined in Europe, but even there, it's examined by one European patent examiner, and once a decision is made as to whether it's patentable or not, it then issues into individual countries in Europe. But in order to have protection in each country, you have to have a patent in each country. And so if it's important, if you're marketing or if you're selling a product in different countries, or if you're manufacturing it in other countries, it may be important to have a patent filed for and granted in each of the countries where you're making and using and selling that product in those countries. And even if you're not, you may be able to, even if you're not making or using it there, you may be able to license that technology to a foreign entity in that country. Filing internationally it can be very important to investors who are investing in the company or in the technology. Generally, investors will want to know, where are you, where have you created this right to exclude, and how difficult will it be for competitors to compete in the market. So filing internationally and building a portfolio that includes both a patent in your own country as well as in other countries can increase the value of the patent portfolio. So what are reasons for not filing foreign? The biggest reason is generally cost. Filing internationally can be very expensive. If you wanted to file in say in 20 different countries, the filing costs alone could easily approach $100,000 US. And then there's also some risks of prosecution where there's a potential risk of if you're not successful in getting a patent in one country, the arguments or statements that you make in trying to get your patent, for example, in Germany, for example, there's a possibility that could bear on your ability to enforce your patent in a country where you were able to get a patent. I wanted to talk briefly about costs, just to give you a sense for what the process generally, the costs associated with the different stages. In terms of the preparation, the cost depends largely on the complexity of the invention, how many inventions there are, how much time it takes to describe an invention. Simple mechanical inventions can be described in perhaps even a few pages. A much more complex, sophisticated system that has many components could be 100 pages long, and so it is very much dependent on the complexity of the invention. And so just for ballpark figures, to prepare a patent application could be anywhere from $5,000 to $20,000, and even more than $20,000 for certain inventions. The filing fees, again, it's country dependent, and it depends on the size of the company. Some countries will offer a discount if you're a small company, and then also just how many different inventions there are, the number of claims you have, the length of the patent application. But generally, the filing fees, for example, in the United States are roughly about $2,000. In Europe, it's about $3,500. I think in Japan, it's about that, maybe a little more, $4,000. And then in terms of, that's just to get the application on file. And now to, move it through the examination process, and this is this exchange you're having with the examiner and the different patent offices, that's also complexity dependent. How long you want to fight for broad protection. It could take years, many interchanges with the patent office. And so going through the process of prosecution can be anywhere from $5,000 to $30,000, sometimes even more than that. But assuming you're successful in convincing the patent office that you're entitled to invention, you then get your issued patent, it publishes, and then there are some fees that are associated with just maintaining the patent. And this again is country dependent. In the United States, there are fees that are ever increasing fees due 3.5, 7.5, 11.5, and 14.5 years after your patent issues. And again, they make it more expensive because again, the government is trying to encourage you to give the technology up to the public so that they're free to use it and improve on the technology. And so there are certain technologies where the earlier part of the patent term is more important. For example, in the electrical software, where technology is advancing more rapidly, the earlier part of the patent term is more important. In the pharmaceutical and chemical areas, it's the latter part that might be more important. So, it may be more important to make sure that you get, you use all of the available patent term. I should also mention that in most other countries outside the United States, there are these annuities are due actually every year. So there's a cost associated with even maintaining your patent application while you're in the examination process. And then I thought that I'd also include just a slide that where you can get resources available. The United States Patent Office, the European Patent Office, all of these patent offices, if you Google them, they provide resource information, and you can find a vast resource of information at each one of their websites. There are also other internet resources and blogs that are available generally free of charge. BitLaw, Patentleo, IP Watchdog are all examples of forums where you can gain some valuable information. And in the world of the internet now, in terms of searching for patents and finding out what others are doing, Google has a patent database that is quite extensive, and it's up to date, and you can do a lot of searching for patents yourself, or if you're interested in seeing what other people are doing in your field. So that's generally the presentation. I think the important things to keep in mind are that, again, patents are for new, non-obvious methods, apparatus, and compositions of matters. They are not for covering abstract ideas or laws of natures. The patent is limited by what prior art is in the public. And again, patents provide a right to exclude. They're not a right to practice an invention. The patents, the claims at the end of the patent define the scope of your invention, and it's a monopoly that is a time-limited monopoly that is given in exchange for teaching the public how to make use and make use your invention. And again, it's limited to the country that's granting the patent. There's a lot of material there. I really was, I made some generalizations. Again, I encourage you that if you have any questions specifically, in your own country, that you can consult with an attorney. I'm providing my own contact information, and if you have specific questions, you're free to contact me if you want more information or details. I'd be happy to help out. So at this point, here's my contact information, and I guess I will turn it over to Paul now, who can, if there's some other questions.
Thanks, Frank. Yeah, a couple of questions to make our way through. If anybody else has additional questions, please type them into the chat box or the Q&A box, and we'll get through as many as we can. So Frank, in flying device design, it's probably likely there's going to be many different iterations of the design before something's settled on that's the final design. How do you think about a intellectual property protection strategy that fits with that sort of developmental design?
Well, this is a great, it's a really good question, and it doesn't necessarily relate just to a you know, for the GoFly inventors and the inventions that they're developing, but there's this tension between when do you actually try to file for a patent application, and or do you wait to try to iron out all of the details and make sure that it works? Generally, there are ways that you can try to cover the generic aspects. So from our standpoint, there's always the risk of waiting too long because someone else could be doing in parallel with you developing the same sort of technology. And so there's this risk that if you wait too long, someone else could get in and file earlier than you, and then you would be then prohibited from, they would be able to exclude you from practicing your invention. So we generally try to encourage people to contact their patent attorney to discuss, you know, if they have the generic concepts and they have a pretty good idea of how it's going to work. That is probably enough to protect the broad aspects. As you continue to develop and your product, that you will undoubtedly come up with other inventions, other improvements, features. As your first prototype might have problems, and those problems are often the genus of other inventions. Having solved that problem, then you've come up with another way. You know, we need to change the nozzle design. There isn't enough pressure fluid. So even though you have a patent application that's covering the generic design, there's no requirement that everything has to work and that you've actually reduced it to practice to file a patent application. You can have follow-on patent applications that cover the improvements. And so this is how a portfolio is built. Oftentimes, a patented invention is covered by many patent applications. One that's directed to the generic idea, and then there are other patent applications that are directed to some of the specific features that actually are maybe as equally important and maybe more important, because those are the features that are actually the way that the thing actually works. In the United States, this provisional patent application is also a tool that's used where you file a provisional patent application and to the generic idea, and now you have a year to sort of iron out some of the details. And then when you convert that provisional patent application into a utility patent application, or many provisional patent applications, you can roll all of the disclosure and all of those provisional patent applications into one utility patent application. Now, you should understand that each of the inventions, again characterized by the claims, may have a different filing date, essentially. You know, so the prior art. That's why getting an early filing date to the generic idea is important. But you know, at the same time, the improvements might not get the benefit of that earlier filing date, because it was only after, at the time of when you file the provisional patent application, that you have the improvement.
Great. And then you talked a little bit about the first to file concept. Could you say a couple of words about that and how that plays with the strategies of when to file a potential provisional patent?
Mm-hmm. So again, you know, it wasn't until, well, it's not that recent anymore, but in the United States anyway, we were one of the few countries that was really a first to invent country, and that was essentially to allow you know, the small inventors that didn't have the same financial resources as a larger company to be able to still be able to protect their inventions without necessarily getting their application on file. That's changed, and generally today, the world has harmonized to a first to file. It's the first one to file an application generally gets priority to the invention. So again, going back to related to the first question, there is really an impetus to try to get an application filed earlier in the game. Now, that doesn't mean that you want to file immediately after you come up with an idea, and you have to keep in mind that there is this requirement that you have with the patent application that you have to actually be able to teach somebody how to practice and use an invention. So just having an idea without something to support how you would actually make it or use it, you have to at least have some basis for how you would make and use something and describe it in enough detail that someone could actually go and try to do that. Again, if it's a poor version and doesn't work as well as you might expect, that's probably not going to impact the validity of your patent. But you generally want to try to get your patent filed earlier, because the first to file is really going to be the one who dominates.
Great, thanks. Can you talk a little bit about the strategies people might think about for protection across multiple countries? Is a provisional patent something that is consistent throughout the world? And are there any time constraints you need to think about between filing in one country versus multiple countries?
Again, this is a really, and it's an excellent question, and I could spend an entire hour talking about all of the strategy for protecting inventions. So most countries are signatories to a treaty that was signed by most of the developed countries in the world many years ago, probably 50 years ago, called the Paris Convention. And in general, if you file in your country, the country of origin, so if you're in Germany, you're a citizen of Germany, you file a patent application in Germany, you generally have a year to be able to file protect your invention in other countries that are part of the Paris Convention. So you have a year to decide whether you can file in each of those countries. There's also another treaty that was developed after the Paris Convention called the Patent Cooperative Treaty, and people who have looked into this a little bit may have heard of what's called a PCT application. This is an application that doesn't mature, is never granted into a PCT patent. It's just an application. Again, it can be filed within a year of filing your first application. And in the United States, that would either be the provisional patent application, the first time you file the provisional, or your first utility patent application. You have a year to file a PCT application. The cost is about $3,000 or so, and it covers, again, most of the developed countries in the world. I don't know how many there are. There's well over 100 countries, I think, that are in PCT. Some of the one important country that's not part of the PCT is Taiwan. So this might be important or relevant, for example, in the aerospace industry. That if you wanted to get protection in Taiwan, you can't use PCT. You would have to file an application in Taiwan. The benefit of a PCT application is it's sort of it allows you to delay your decision, and it can delay committing costs, all the high costs associated with foreign patent protection, because when you file the PCT application, there is a brief search that's done. It's examined. A search is done, and then the examiner issues some prior art that he's found, and that may impact your decision as to whether to proceed with your patent application in your own country or even in foreign countries. And it also delays the decision to go forward in all these foreign countries for an additional 18 months after you file your PCT application, or essentially 30 months after you filed your first application. You can actually delay your decision to go into those countries, and in 30 months, hopefully, you'll have a better idea whether your product is being commercially successful. Also have a better idea of whether the invention is in fact patentable. And so there's a great deal of potential cost savings by going the PCT route.
Great. And then what if you decide not to patent your idea? What happens? Can you be successful? Can somebody else patent it and prevent you from continuing to build that idea? What happens if you just don't file?
Well, there is no requirement that you have a patent to be successful in the business world, and there are lots of companies out there who don't have patents, and they're successful because they're good at what they do, or perhaps there's so much prior art out there that essentially what they're doing differently is just an incremental improvement on what's generally out there. But if that incremental improvement turns out to be the difference between why somebody is buying your product than someone else, then that's the risk of not having patent protection. For certain kinds of inventions, say, a semiconductor fabrication process, some recipe for a chemical formulation, the Coca-Cola trade secret, those are things that you might want to just decide that you're going to keep as a trade secret. If you're confident that you can keep it that way and that you trust the people that you're sharing, that know and understand the trade secret, then that very well may be the better option than filing for a patent. But the risk is always that if it does get disclosed, then someone else will be able to do it. And again, it's really, there are a lot of patents out there that probably are not the the inventions that they cover are not the reason why the companies are in fact successful. But so there are lots of companies out there who are doing quite well without having a large patent portfolio.
Great. And then just briefly, since we're getting close to time, are trade secrets something that are prevalent in the aviation business?
I guess the kind of thing that I could imagine that might be something that you would, in the aviation business, that might be kept as a trade secret rather than patent is for example, like an algorithm, some software algorithm that's used for controlling a system, so it might be software based, right? And again, you'd want to have all the things in place to make sure that whoever you're selling it to, you wouldn't sell them the source code or have access to the source code. The kinds of things that you want to protect with trade secret are the things that are difficult to reverse engineer. The things that the public can't see, if it's to the device or the apparatus, I would expect that in the aviation industry, if you built this a system, if someone can go and look at it and say, oh, I see how they connected that. Gee, that looks interesting. That's going to be difficult to, that's not going to be a trade secret. It's going to be pretty, obvious to someone who knows the industry and knows the technology. They're going to be able to figure out how you did it. Things like software, methodologies, processes, that might be a candidate for a trade secret.
Great. And then again, very briefly, maybe just do you have a one sentence wrap up word of advice to competitors who might be listening?
To competitors, you mean in terms of
those competing in the Go Fly Prize?
Oh, I see. Yeah. So I think the one thing that I would the one piece of advice I would have is that before you disclose, there's a tension to promote your invention and your idea. And to be successful, you have to be good at promoting your inventions and your ideas, and that's how you're going to raise money. So there is always this tension between promoting and disclosing. So one thing I would always advise is talk with your patent attorney or consult with a patent attorney about any plans that you have for disclosing your invention, even if it's to investors, and they may be able to give you some advice as to how much you should disclose or how to disclose it without destroying your right or forfeiting your right to protect potential inventions.
Great. And then to close us out, I'll just pass it over to Gwen for a parting word.
Well, Frank, thank you very much for an illuminating master lecture. I am sure that all of our innovators gleaned a tremendous amount from it. So thank you very, very much. We are thrilled to have had you at this master lecture. We look forward to another master lecture this week, actually, on how to structure your corporate entity. And thank you all. We wish you a wonderful day, and best of luck to all of our innovators around the world.
Thanks, Gwen. Thank you, everybody.
Thanks, Frank.